Hello everyone and welcome to today's Mondak webinar in association with Gurner Law Office, focusing on remote working in Turkey. My name is Dan Sampaio and it's my pleasure to introduce you to today's wonderful panel. Burçak Kurt Weiser, a partner at Gurner Law Office, regularly advises major international and Turkish clients on all aspects of employment law issues, including mass layoffs, redundancies, employment disputes, transfer of employees, employment issues related to local and/or cross-border M&A transactions, and internal investigations due to suspected white-collar crime. Ergükan Siba is an associate of Gurner Law Office. Ergükan has been working on various areas of law, including corporate and M&A, data protection law, employment law, e-commerce law, TMT, and competition law. He has significant experience in data protection law and provides his clients with tailor-made advice on complex data protection matters, especially international data transfers and transfer of health data. Dolgaç Karaca joined Gurner Law Office in 2020 as an intern and has become an associate in June 2022. He focuses on corporate M&A, employment law, contracts law, and data protection law. He assists his clients in their corporate law and employment law related matters. Now, before I hand you over to our panel, a housekeeping item, you can submit questions to our guests today by typing them into the questions pane of the control panel. We will endeavour to answer as many as possible during our Q&A at the end of today's session, but all questions will be sent on to the panel. It's now my pleasure to hand you over to Burçak, Ergükan, and Dolgaç. Thank you.
Thank you so much, Dan. Hi, everyone. Thank you very much for joining us today. Dan has kindly introduced us to you, but I would like to make also a brief introduction. My name is Burçak Kurtbiçer. I'm a partner of Gurner Law Office. I'm heading the firm's employment practice. Today, my colleagues Ergükan Şeber and Dolgaç Karakurt are also with me, and they'll be answering your questions at the end of the webinar. Before starting, we would like to thank Mondak team for giving us this opportunity to meet you all. As we all know, in not so distant past, remote working was almost a taboo for the employers. Most of the employers believed that as they wouldn't have enough supervision over their employees, they would not be able to, continue their operations in the ordinary course of business. However, during the pandemic, thanks to remote working supported by the high-end communication technologies, the employers have been able to continue their businesses nearly in the ordinary course of business. So it was really not a common concept when the pandemic has started, and the lawyers, employers, and HRs had difficulties and still continue to have difficulties on how to implement and regulate remote working for their employees. Based on our experience and the requests that we received from many of our clients, we decided to provide you with detailed information on how to regulate and implement the remote working arrangements in the best way possible from legal perspective. I hope this webinar will be helpful for you. Let's review the titles of today. We are going to start with a brief introduction to the concepts and then give you some statistical information on remote working. After that, we'll provide details of the Turkish regulation on remote work and identify the risks and obligations for Turkish employers. We'll also talk about how the foreign employers can have their employees work remotely in Turkey, international remote working. We'll also look into the data protection aspects. And finally, we'll suggest you the best methods for arranging remote working of employees. Let's start with the brief introduction to the remote work and other related work types. To better understand the relevant concepts, first understanding the default place of work would be helpful. According to International Labour Organization, default place of work is the place where you expect an employee to typically work at. The default place of work could be the office or facility or plant of the employer where the employees work physically, or a client's office or facility or plant where the employees again work physically. Also, public spaces would also be considered as default place of work in the case of employees who are expected to carry out their duties on public spaces like street vendors or police officers on patrol. The second concept is remote work. Remote working can be described as situations where the work is fully or partly carried out by the employees on an alternative work site other than the default place of work by using the information and communication technologies. The other concept is telework. Telework is actually very similar to remote working, but there are very minor differences between these two concepts. In telework, some in-person office attendance is required, while the remote work in principle does not require office attendance. I say in principle because in practice it differs. A remote worker is principally expected to meet the colleagues and customers in a virtual manner. A teleworker is often located closer to the main office location than a remote working employee. And a teleworker has to log on during regular business hours for their employer's time zone, while the remote worker can work from anywhere regardless of the time zone. In principle, I can say. The other concept is hybrid working. We are hearing it too much nowadays. Hybrid working is a mix of work at the default place of work and remote working. Hybrid working can also be categorized and may differ from employer to employer. The first one is hybrid at will. In this type of hybrid work, the employee chooses the days to come to office. Hybrid split week, in this kind of hybrid working, the employer assigns the specific days for on-site and remote working by team of function. And the hybrid manager scheduling, basically the managers choose the days the employees come to office. And the last one is working at home. In that type of work takes place fully or partly within the employee's own residence. As you may see, all these concepts are related and there is an overlap between each other. And while you are saying that I'm working remotely, maybe you're actually referring to teleworking. But from Turkish law perspective, it is completely okay because the definition of remote work under Turkish law is a blend of these concepts, we can say. Before going into details of the definition and details of the remote work under Turkish law, let's look at some statistical information on remote working. According to a study done by Global Workplace Analytics, found that remote workers have grown by 216% from 2005 to 2020, and it has accelerated over 2019 and 2021 during the pandemic, we can say. In Turkey, statistics suggest that remote work rate rose 10 times in 2020. It was 5% at the beginning of the year, and it was 50% at the end of the year. A survey conducted by Buffer suggests that 97% of the employees who have worked remotely before would recommend remote working to other persons as well. Based on Upwork's projections, over 40 million American employees will be working remotely full-time by 2026. Lastly, 54% of the employees from around the world would consider leaving their job post-COVID-19 pandemic if they are not afforded some forms of flexibility in where and when to work. So we can say, on average, employees would want to work between 2 and 3 days remotely after the pandemic. Given the statistics, we can say there is a serious demand from the employees for remote working, and remote work will continue to be on our agendas in the near future. Now, let's review remote working from Turkish law perspective. And let's start with the introduction of remote work concept under Turkish law. Actually, it is a very new concept under Turkish law and has just been introduced back in 2016 by way of an amendment to the Turkish Labor Code. And before the introduction of the remote work under Turkish Labor Code, home-based service contracts set forth under the Turkish Code of Obligations was being applied. And actually, the elements of home-based service contract are very similar with those of the remote working. And home-based service contract is also a new concept under Turkish law. It entered into force back in 2012. With the amendments in 2016, the definition and general principles of remote work have been added to the Turkish Labor Code. And in the amendment, it is stated that there will be a detailed regulation on the remote work, but it has taken approximately 5 years for the entry into force of the amendments, and it has been issued right after the pandemic back in March 2021. So we can say, as happened in the whole world, pandemic has been a milestone in terms of the regulation of remote work in details under Turkish law. Let's look at the details of the remote work and the gray areas under the regulation. According to the regulation, remote work is a written employment relationship based on the principle that the employee performs the work at home or outside the workplace with the help of the technological communication tools within the scope of the work organization created by the employer. This is the definition under remote work, and as I said before, it is a mixture of all relevant concepts, we can say, home-based work or remote work and telework, we can say. Although the regulation introduces many details on remote working, it is criticized for leaving some areas gray. And, you know, there are no sufficient court decisions at this stage to fill in such gray areas. So there are many views among the practitioners to fill in the gray areas under the regulation, and there are mostly discussed subjects, and we are going to give you a few examples regarding such gray areas. For example, it is highly discussed, especially at the beginning of remote working during the pandemic. Will the employer continue to pay transportation and lunch allowances after the employee switched to remote working? On the lunch allowance, we can say there is a common understanding between the practitioners, and everyone thinks that if the employer was paying the lunch allowance to the employee when the employee was working physically at the workplace, then it must be paid to the employee during the remote work as well. In order to cut this allowance, the employer has to obtain a written consent from the employee, otherwise it cannot be implemented by the employer. As to the transportation allowance, there are different views. Actually, there are two views. One of them suggests that if the employer was cutting such allowance when the employee was on sick leave or annual leave, then the employer may cut the transportation allowance when the employee is working remotely. And the other one states that if such allowance was being paid to the employee regardless of the leave days, then it is a fixed part of the salary of the employee, and it must be paid even the employee starts working remotely. We believe that since there are no court precedents yet in this respect, and in order to remove a payment like this, a consent from the employee is required under Turkish Labor Code in principle. We believe that it would be safe to pay the transportation allowance also after the employee switches to remote working. Another gray area is the status of collective agreements. It is questioned if the employers will be granting the rights under the collective agreements to the employees when they start working remotely. Actually, according to the regulation, the remote work location should be accepted within the scope of the business organization of the employer. Therefore, the employees working remotely should benefit from the collective agreement which is applicable at the workplace, and also the remote workers can be a member of unions and can establish a union. Now, let's move on to the details of remote work as regulated under the regulation. The regulation provides the minimum content of the remote work arrangements, which will be in writing. Accordingly, the definition of the work to be performed, the method of working, duration and place where the work will be performed, salary and payment terms, the equipment to be provided by the employer, and the obligations regarding the use and protection of such equipment, communication method between the employer and the employee, and the general and special working conditions must be in principle included in the remote work arrangements. We are going to review some of the subjects that will be taking place under the remote working arrangements. And the first one is the definition of the workplace. Actually, explicitly defining the place of work is significant in terms of the employer's obligations on the workplace health and safety, as the places where the work will be performed are going to be deemed as a part of the work organization. In the event of an accident in one of the places listed in the agreement, these will be considered as work accidents. We'll go into details of the health and safety matter and work accidents in the relevant parts of the webinar. The other subject that must be covered under the agreement is method of covering the costs for preparation of the place for the remote work. Actually, the remote workplace must be prepared before the employee starts working remotely, and the parties need to have an agreement in respect of the costs for the preparation of the workplace. Such costs may be, providing a proper desk, proper chair to the employee, proper lighting, air conditioning. The responsibility of parties on expenses for such kind of preparations must be agreed between the parties. The other one is the procurement of materials and equipment and the coverage of expenses. Actually, in principle, the employer is expected to provide these materials to the employee. If the employee use their own materials and equipment for carrying out the work, then the employer should cover the expenses and pay an equitable fee to the employee for the use of their own equipment for carrying out the works. Also, coverage of compulsory expenses directly related to the production of goods and services arising from the performance of the work should also be regulated under the agreement. The regulation is silent about the responsibility of the parties, but according to the Code of Obligations, the employer will be responsible for the expenses necessary for the performance of the work. The other subject is duration of work. The time interval and the duration of remote work should be specified in the employment agreement. The parties can modify the working hours by complying with the limitations under the legislation, and overtime work can also be performed if the employee accepts it. Under Turkish law, normal weekly working hours is 45 hours. And works performed over 45 hours are considered as overtime work, and overtime work cannot exceed 11 hours a day, and the total duration of the overtime works in a year cannot 2,070 hours. on a yearly basis. Determining the overtime work in case of remote work is a problematic area. According to the decisions of the Supreme Court of Appeal, since the employee has flexibility to arrange the working hours while working remotely, it is, the employee, if the employee claims overtime working, it is necessary to rely on clear evidence in proving overtime work. For instance, in a decision in respect of a claim from a pharmaceutical representative, the court has decided that overtime work cannot be evidenced with a witness acknowledgement in this person's case, as this person is all the time outside the workplace, and it is not possible for the witnesses to see if there has been an overtime work in the case of a pharmaceutical representative or not. So in this context, working hours recorded by remote time tracking software would be used as evidence by the employers. Also, under Turkish law, it is possible to state that the salaries of the employee will also cover the overtime works to be carried out by the employee. So it would be a safe method to regulate this under the remote working arrangement to prevent any potential overtime work claims during the remote working, because it is hard to evidence it. And the other matter is protection of data. The employer is obliged to inform the employees about the business rules and relevant legislation on the protection and sharing of data, and to take necessary measures to protect the relevant data. Such rules as not leaving computers and mobile phones in a way accessible by third parties in public areas, connecting to secure networks, and using tools such as VPN for safe connection should be indicated in the agreements. We'll be providing detailed information on data protection aspects of remote working in a later stage of the webinar. And the other subject is health and safety. Actually, the regulation does not regulate the health and safety matters specifically, but provides general terms in this respect. In case of remote working, the employer's right to control the employee is kind of limited, considering the constitutional rights like the right to privacy and the immunity of domicile. It is too difficult for the employer to make sure that occupational health and safety measures are duly implemented by the employees at their remote workplaces. So, considering there are certain uncertainties on this matter, the employer is obliged to duly inform the employees about the occupational health and safety measures, to provide necessary training in this respect, also for the use of the equipment provided by the employer. Employer's liability is not unlimited, of course, and if the employer fulfills such obligations, to provide trainings, to take necessary measures, and to inform employees about the principles regarding the workplace health and safety, then the employer shouldn't be liable for the work accidents occurred during the remote working in principle. In respect of the health and safety measures that can be taken for remotely working employees, we can look at the International Labour Organization's Healthy and Safe Telework Report, because we do not have detailed provisions under the regulations, so this would be a guidance for the employers. Accordingly, these measures would be as follows: providing remote workers with necessary equipment that complies with ergonomic standards, periodically upgrading the ergonomic standards and policies, informing the employees that taking necessary breaks will not result in negative career setbacks for them, encouraging frequent exercise to employees, and increasing options to psychological support systems. By the way, also, although not widely known by the practitioners, we have a regulation on health and safety precautions in working with display screen equipment. This regulation was actually entered into force back in 2013, and it was prepared based on the relevant Council directive of the European Union, and regulates in detail the obligations of the employer to diminish the risks of using screen tools with a risk assessment conducted in the workplace. Such risks would include vision-related problems, obviously, physical problems, or mental distress. The employer is obliged to give proper training to the employees covering correct way of sitting, protection of the eyes, fonts and colors that are least affecting the eyes, rest breaks and exercises, and medical eye examinations. And we also need to look at the results of a work accident because such work accidents could affect some third parties or family members of the remote worker. According to Turkish Code of Obligations, the employer is obliged to compensate the third parties who are affected by the actions of the employees while they are carrying out the work for the employer. So the employer must be in a position to prove that it has taken all necessary care to prevent the damage from occurring while recruiting the employee, and he has given all the necessary instructions and has taken all the necessary measures. So only by proving, the employee has taken all necessary steps in this respect, the employer would be, get rid of the responsibility in case of any claims from the third parties. Of course, the employer has the right to recourse to the employee for such kind of damages if the employee is at fault. The last point is that remote work cannot be performed in jobs that involve hazardous chemicals and radioactive materials. Okay, let's move on. The employee's request for working remotely. Actually, this subject would be of significance as some of the companies are currently planning to go back to offices on a full-time basis or implementing hybrid work. Pursuant to the regulation, it is possible for an employee to request working remotely. Such request must be submitted to the employer in writing, and the employer has to provide its response within 30 days. The employer will make its decision by evaluating whether the work and the employee is suitable for remote working. Also, the employer should create other evaluation criteria for such kind of requests. While creating this evaluation criteria, the employer has to act in accordance with the good faith principles, and these criteria must be objective. And while evaluating the request, the employer must also again comply with good faith principles and must make a decision in a manner protecting the functioning of the business and the order in the workplace. And while evaluating the requests from the employees, obviously the employer has to equally treat the employee's request. If the request of one of the two employees performing the same work and having similar seniority is accepted and the other is rejected, the rejection of the other employee would constitute a violation of the employer's obligation of equal treatment. However, the equal treatment obligation of the employer is not limitless. For example, in case of a security personnel, it is not possible for the employer to accept a request for remote working due to the nature of the business. But in the same workplace, a computer engineer may also request working remotely, and the employer may request such request, may accept such request from the employee. So the nature of the business is also important for the employer while making the decision on the request. Also, discrimination compensation can also be demanded by the employee if the employer rejects the request of an employee because of the employee's language, religion, race, gender, political view, philosophical view, or other similar reasons. Of course, the employee must prove that the demand has been rejected due to such kind of reasons. And when the employer reveals a situation that strongly indicates the possibility of a discrimination to that specific employee, the employer is obliged to prove that such a discrimination does not exist. Also, remote workers cannot be subject to different or unequal treatment compared to their peers working in the workplace due to the nature of their working arrangements, unless there is a major reason which justifies such different treatment by the employer. Also, the employee who has to wish to remove work can request to work at the workplace again by applying to the employer in writing. And in case of such a request, the employer must evaluate this request again in 30 days and notify the employee in writing. And the other subject is the employer's right to request the employees to work remotely. The employer can request the employees to work remotely by obtaining their written consents. According to Turkish Labor Code, if such consent is not given by the employee within 6 business days, then such change will not be applicable and binding for the employee. Of course, there are certain situations which does not require the employer to take a written consent from the employee. These reasons can be epidemic, pandemic, other force majeure reasons, fire in the workplace, earthquake, and decisions of any official institution, etc. In these kind of force majeure events, then the employee's consent is not required. And now, after, due to such kind of force majeure reasons, if the employee starts working remotely, then the employer may at any time, by using its managerial rights, request the employees to go back to physical workplaces. Now let's look at the obligations and risks of Turkish employers regarding the remote working. We have actually talked about these obligations and risks, but let's have an overall list in front of us. First one is the obligation to have a written agreement, and the other one is to notify the Social Security institution on the number of remote workers and the number of the days worked remotely. This is for statistical purposes, by the way. Obligation to equally treat the employees when evaluating their request for remote working. Obligation to equally treat the employees working remotely and working at the workplace. Obligation to provide occupational health and safety trainings and to take necessary health and safety measures. Obligation to inform the employees on the data and information security policies, to provide necessary trainings in this respect and to take necessary measures. And finally, the obligation to provide necessary equipment and to pay the compulsory expenses. The major risks of remote working, as we have already talked about, would be work accidents, data breach risks, and third-party claims. The other subject is international remote work. Actually, with the increase of remote work globally, we are seeing many remote workers working outside the countries where they legally reside and work. We believe that going forward, many companies will be allowing their employees to carry out remote work internationally. However, currently there are various legal issues regarding the international remote working. So before starting to implement international remote working, the employers need to obtain information on the local laws of the country where the remote work shall take place. International remote working actually is still a developing area, and it's a work in progress across the world. And we expect the countries to have specific regulations and treaties on international remote working, considering the demand from the employees in this respect. Let's review the important legal issues under Turkish law regarding the international remote working. First one is the applicable law. According to the international private and procedural law, the governing law chosen by the parties under the employment agreement will be applicable. However, in case the relevant law does not provide the minimum protection provided by the Turkish laws, the habitual workplace law, which is the Turkish law, shall be applied for the relevant matters. When we are saying the habitual workplace, we mean the place where the employee actually performs the work. And while determining the habitual workplace of the employee, the country where the employee predominantly performs the work in terms of quality, quantity, and duration should be taken into account from Turkish law perspective. Therefore, in most of the employment, in case the employee works in Turkey in most of the employment period of the employee, then the Turkish laws would be applicable for the matters for which the Turkish laws provide more protection to the employee compared to the law chosen by the parties under their working arrangement. Okay, we can move on to the social security related issues. Pursuant to the law on the social security and general health insurance, persons who are registered with the social security system abroad and assigned to Turkey by an establishment abroad for a maximum period of 3 months will not be subject to Turkish social security requirements. So we need to be careful about 3 months restriction under our laws in case the employee chooses to work remotely in Turkey without the assignment of the foreign employer and does not conduct any transaction or commercial operations with the persons here in Turkey on behalf of the employer, and the salary payments of the employee are made to the foreign bank account of the employee, there will be no registration, licensing, payment, or filing obligations for the employer in Turkey. And the other important issue is the immigration aspect of international remote work. The employee of a foreign employer can work remotely in Turkey without a work permit to the extent that the employee does not conduct any transactions or commercial operations with the persons here in Turkey on behalf of the employer. Also, in case of a foreign employer, it is not possible to get a work permit from the Ministry of Labor, as our laws require the employers to have a duly established company in Turkey in order to be eligible obtaining work permits for their foreign employers. So it's not possible for foreign employers to obtain a valid work permit from Turkish authorities. On the other hand, if the foreign employee will stay in Turkey more than 90 days, such employee is obliged to obtain a residence permit. But considering the latest immigration developments in Turkey, there are so many immigrants in Turkey, and there are now certain limitations granted by the authority, and Turkish immigration authority is rejecting touristic residence permit applications for non-Turkish employees or non-Turkish persons, we can say. So non-Turkish remote workers can only stay in Turkey for a maximum period of 90 days based on a touristic visa only. During the remote work, non-Turkish remote workers shouldn't perform any additional works as a contractor or a freelancer, or receive any payments from any person located in Turkey. Otherwise, the remote worker will need to obtain an independent work permit from the Ministry of Labor. So, considering all of these explanations, it would be advisable to limit the remote work of a non-Turkish employee with a maximum of 90 days in order to avoid any possible immigration-related risks. And occupational health and safety is another subject that the foreign employers would be careful. Some rules of Turkish law are classified as overriding mandatory rules, and these are applied regardless of the law chosen by the parties for the purpose of protecting the social, economic, and political structure of the state. And the occupational health and safety rules are generally accepted as falling in the scope of overriding mandatory rules of Turkey. Therefore, even if the employment relationship is subject to a foreign law, Turkish rules regulating the occupational health and safety would be applicable for the employee working, a non-Turkish employee working in Turkey. We think that the only situation that would actually require implementation of the Turkish health and safety rules would be the work accidents in Turkey. If in case of a work accident involving a foreign remote worker, if there is a multilateral or bilateral social security treaty between the country where the employee is registered with its social security system and the Turkey, the employee's social security can be continued before the Turkish social security institution. And in case the bilateral treaty includes the payment of work accidents and occupational illness payments to the employee, then the foreign employee can benefit from such payments subject to the provisions of the relevant treaty between the countries with the help of Turkish social security institution. But in case there is no treaty between the countries, then the social security institution will not have any obligations, obviously, to pay any allowance or compensation to the employee for work accidents. So, considering the occupational health and safety risks in case of international remote workers, although it is not mandatory under Turkish law, it would be advisable to have a private health insurance covering the time of the employee in Turkey. Let's move on to data protection aspects of remote working. After the remote work has become quite common, various issues in terms of the protection of personal data have occurred. Basically, employers may process different types of personal data of their remote working employees due to remote working. Accordingly, employers may need to be making additional data privacy statements to their remote working employees, or maybe obliged to obtain additional written consents from their employees for certain data processing activities that they carry out due to remote working of the employee. So what kind of processes can be subject to these obligations? For example, employers may wish to monitor the work efficiency of remote working employees with various mechanisms and applications. The employers are generally trying to monitor the keystrokes and mouse movements of employees, taking screenshots from their screens, accessing the applications that the employees use when they are working remotely, and accessing their webcams and collecting images by installing certain software, etc. So this kind of data processing technologies are generally considered as not proportionate, and it would be unlikely to have a legal ground under legitimate interest for the employers. So the employers must always consider if such methods are reasonable and proportionate. One of the most important issues is the technical and administrative measures that should be taken by the employers when they are carrying out remote working for their employees. Since the Wi-Fi's located at homes are more vulnerable than those at the offices, data breach risk is higher. Additionally, sending of the work-related files through personal emails instead of business emails is another problem. Data Protection Board indicated in a statement that in order to minimize the risks, all measures ensuring that there is no vulnerability in the data sharing traffic must be taken, the antivirus systems and firewalls must be updated, and the employees should be enlightened on the data security. Taking measures related to the physical environment where the personal data is stored is also a challenging matter. The board requires the taking of adequate security measures for the protection of the physical environment against the risks such as electrical leakage, fire, flood, burglary, etc. Taking these measures in for remote workplaces of employees at their homes, for example, would be nearly impossible. So we are of the view that the employers must not allow remote workers to store any personal data in their physical environment. Okay, we can move on to the final subject. So considering all our explanations during the webinar, we can say best method for implementing remote work for Turkish employers would be having a written agreement. Of course, it's an obligation under the law, but regulating in sufficient detail, especially the place of work, health and safety, procurement of equipment, responsibility of parties for expenses, work hours, and protection of data. And the best methods for implementing remote work for non-Turkish employees would be explicitly defining the governing law of the remote working arrangements and the place of the remote work, considering the potential health and safety issues and work accidents in Turkey, and not to exceed 90 days for SSI permit related and social security related exemptions. Okay, thank you very much for joining us today again. And now we are going to answer the questions that we have received so far. If any, I don't know. My colleagues Uğurkan and Doğaç will be helping us in answering these questions if there are any.
So thank you, Burçak. We can jump into Q&A session. We have several queries from our audience, but as we have this explaining data protection measures, we will not announce their names as well. So first query is, has the Turkish legal industry adapted to practice of outsourcing remote legal work overseas? So in order to explain this query, as Burçak mentioned our presentation clearly, and to be honest, there is no clear provision, especially international, based on the international treaties. Yes, there are some outsourcing companies already hiring the remote workers in Turkey from companies overseas. And I can give some examples for that. Let's say for content reviews, for social media platforms, and etc. However, as you know, as the remote work is quite new concept around the whole world. So we, in order to establish an international law that covers whole international problems, there should be an international treaty at first in order to each country to adopt and similar, let's say, similar provisions under their law. So from this stage, as of today, there is no, let's say, practice adopted under the Turkish law yet. I hope this is clear for the So, second question, will employing people in Turkey by an overseas company create a service permanent establishment in Turkey and consequently become taxable as regard to profits attributed to such permanent established? So, maybe Doğaç can revert this query.
Hi all, thank you for your audience and patience. I may first I should mention that we are not tax law experts, so the taxability of such situation is not within our expertise. But I may try to give some explanations to this query. If there's no authority granted to the employee to represent the employer or authority to contract on behalf of the employer, I think that there should be no permanent establishment. This should not be. This should not lead to a permanent establishment with from a perspective of Turkish law, and the taxability side is under the tax law number 1510. If there is no residence exceeding 6 months of the of an employee or person, there's no taxability within. There's no full taxability with the earnings of the employee, but considering the expenses of the employee, etc., there's a restricted taxability under Turkish law. But as I said, we are not tax law experts, so our expertise is very narrow, and I mean, we not cover the tax law issues generally. So I hope my answer was helpful, but if there's any other questions.
Yeah. I want to make a clarification in this respect, in case, by way of the services of the employee, if any revenue profit is generated in Turkey by the overseas employer, then as Doğaç said, such employer will probably be responsible to Turkish tax authorities for such profits and revenues generated out of the activities carried out in Turkey. So in order for an employer, for foreign employer, not to be subject to Turkish tax laws and social security laws, it is very important to make sure that the employee does not carry out any activities, commercial activities or transactions with the persons here in Turkey on behalf of the employer. Otherwise, there will be taxation and social security related risks.
Okay. We have further query based on our first response, and it says, does it matter if we have professional contract rather than an employment contract for the employees who works overseas? For probably, okay, this question comes for yes, it's for the same, outsourcing the legal work. So our attendee asks, does it matter if we have professional contract rather than an employment contract? Okay, I can answer this question. So if we have a professional contract rather than employment contract, in this case, under Turkish labor law, actually, and there are some differences by and between service, I mean, professional contract and employment contract. And in some cases, and most of the cases, the Turkish courts already admitted, some works cannot be outsourced for, for the procurement of a service and etc. If these services can be conducted in the place the employee works. There are several differences. Let's say if there are some bullet points in this respect. If the employee full-time works for the employer, and if he or she conducts that place at the place of work, but in this case remotely conducts its job, it is he or she dedicates her time or his time fully to that employer based on that contract. And there are several differences. If you are trying to, take yourself out of the employment contract concept, most of the times the Turkish labor courts do not accept such contracts as professional or service contracts. Therefore, most of the time, employers will face a certain kind of penalties from the social security institution, as they are not registering them before the social security institutions, and they do not pay their premiums. So briefly, it depends of what kind of service that person will provide you. It will change depending of the service.
Yeah, I want to make some additions to these explanations. Actually, if even if the contract's name is professional contract, it's called as a service agreement, there would be a risk that, as Urkan said, it would qualify as an employment contract under Turkish law. So when arranging this kind of contracts, the employers must be careful, because when they are thinking that they will have no liability for the professional that they are having a contract, maybe they are actually creating an employment relationship, and there may be certain employment claims from such professional in the future. And as Urkan said, there will be serious penalties from the Social Security institution for not making the necessary employment-related statements to the Social Security institution. And now for the Social Security premiums that haven't been paid for such person, during the professional contracts term. Therefore, we need to be very careful when drafting this kind of professional contracts from Turkish law perspective, and we need to make sure that it is actually not an employment relationship from Turkish law perspective.
Thanks for the clarification and additional information, Burçak. So we have, let's say, we have 2 more minutes, so we can have another question. So the question is, we have a remote worker policy that is standardized by how far an employee is from office. If more than 75 kilometers, that employee is considered remote, and the company outline the benefits available. So all employees are treated the same, and there are additional benefits that are outlined that these employees are eligible for. Is there anything more the company needs to consider with this? Doğaç?
Yeah, I may give an explanation to this query. As we said, as Burçak said during the presentation, the employees should be treated equally, and this equal treatment obligation is also covers the non-discrimination or equal treatment between the remote workers and non-remote workers. So I may say that from a Turkish law perspective, this question is for the Turkish law. I think it is. The outlining some allowances or other payments may lead to unequal treatment, but based on the specific terms of the case. So if some payments or allowances are outlined, but there are other payments and allowances, replacing these outlined payments and allowances or side benefits. Therefore, there should not be any case that leads to unequal treatment. But as I said, each case should be considered on its own conditions and specific conditions. Yeah. So.
Yeah. Yeah, actually, I think each benefit must be evaluated on a standalone basis to make a healthy evaluation because maybe there is a benefit that is granted to remote workers due to their, the nature of their way of doing business, because they are working remotely, and that benefit is really required for such employees. But it is not granted to employees physically working at the workplace, just due to the nature of their way of doing business at the workplace. So it would be helpful, to review each benefit on a standalone basis from this perspective, and it must be evaluated if there would be an unequal treatment to the employees who are physically working at the workplace. But overall, yeah, as Doğaç said, this would lead unequal treatment depending of the type and details of the benefits.
Thank you, Ms. Burçak. So we have one last query. I assume then we can exceed our time for a couple minutes for our last query. So one of our attendees asked, you mentioned that the salary should also be credited to foreign account. Did I understand it right? Or foreign currency transfer to a Turkish bank account will be sufficient? So I'm passing this question to Ms. Burçak in order her to make closure and respond last query.
Okay, actually, yeah, we mean that if a foreign employee is working remotely in Turkey on behalf of a foreign employer, foreign or Turkish, it doesn't matter. The employee can be a Turkish employee or a foreign employee. But if the employer is not located in Turkey, then it is advisable to make the payments to the foreign bank account of the employee working remotely in Turkey. Otherwise, there will be some consequences from tax perspective and also social security perspective. In order not to trigger any requirements of Turkish laws, it would be advisable to make the salary payments and other payments to the foreign bank account of the employees working remotely in Turkey for a foreign entity. Okay, I think that's all. And thank you very much, everyone, for joining us today. I hope this has been a helpful guidance for you while determining the best ways to implement and regulate remote working for your employees. And if you have any questions, you may always contact us after the webinar. And I don't know if Mondak team will make a closure as well, but that's all from us.
Thank you very much, Burçak, and thank you for that incredibly informative webinar, and of course for answering our audience questions. We had a lot in, and if yours wasn't answered, it has been sent on to the panel who will be in touch. But as Burçak says, we do recommend that you get in touch with our panel directly. We'll be sharing their contact information in a follow-up email shortly. Thank you again to our wonderful panel, and thank you to our audience for being with us today. I hope we can see you all again soon. Have a great day. Goodbye.